Please be seated. This is a hearing of the Osgoode Hall Supreme Court. This appeal is from the Supreme Court of Canada. We have appellants and respondents. We will go in that order. But first, I'd like to introduce the bench. I am the Chief Justice of the Court, Professor Faisal Bhabha. I'm going to turn to my right and invite each of my brothers and sisters of the bench to introduce themselves.
I'm Lisa Johnson. You can refer to me as Justice. I prefer that you not address me using Ms. or any gendered language. Thank you.
My name is Christopher Diaz. Justice Diaz is fine.
My name is Andrew Monthouse. Justice works as well. Thank you.
Balsam Bashi, whatever you want to refer to me as will be fine.
Kelly Brennan, Justice Brennan is great.
Omar Ha-Radeye, Justice Ha-Radeye is fine.
Neil Singh, Justice Singh is fine.
Owen Cooney, and Justice is fine.
Okay, appellants, please proceed.
Would it be all right with the court if I kept my own time as well as the court?
No problem.
Thank you.
You have 12 minutes.
May I proceed? Thank you, Justices. My name is Navya Sheth, and I'm here with my colleague, Lesha Shah, on behalf of the appellant, Mr. Russell Stephen Tessier, in the case at bar. Would the court require a brief summary of the facts?
That's not necessary.
The question before this court today, Justices, is what constitutes a meaningful choice in the context of voluntariness? It's our position that the Supreme Court of Canada erred in finding that Mr. Tessier's statements were voluntary and thus admissible. And to this end, we have two submissions to make today. I will address the first, and my colleague will address the second. Our first submission is that the confessions rule requires a warning to be given anytime the police conduct an interview in connection with a crime. Our second submission is that, in this particular case, the Crown has failed to meet the high burden required to rebut the presumption of inadmissibility with respect to Mr. Tessier. In light of these submissions, we respectfully request that the Supreme Court of Osgoode Hall allow this appeal, overturn the decision of the lower court, rule Mr. Tessier's statements to be involuntary and thus inadmissible, and order him a new trial. To begin with the first submission, the appellant takes two issues with the majority's framing of the confessions rule. I will address each in turn. The first is that they neglected the informational component of the operating mind doctrine, and the second is that they needlessly differentiated between people at different stages of the justice system. To begin with the first of these, it is our position that voluntariness necessitates an understanding of a choice between alternatives. And although we concede that the 1949 Supreme Court of Canada decision of the Queen and Boudreau did not necessitate a caution, it is nonetheless our position that this informational component requires, as the court found in the 1994 case of Whittle, that the accused must understand that they are speaking to police officers and comprehend that the statements they are making can be used to their detriment.
Counsel, would you agree you're asking us to make a fairly radical change to the underlying decision of the Supreme Court by imposing this new, one might say, bright line requirement?
Justice, we're not asking you to make a radical change. What we're asking you to do is to make explicit an undercurrent that runs through the modern confessions rule jurisprudence, which is that accused persons, and indeed all interviewees of the police, have a right to silence, and in order to exercise that right, must have knowledge of the right. This is most effectively achieved by a bright line caution requirement that then, when failed, gives rise to a presumption of inadmissibility. It's our position that this presumption of inadmissibility is only refutable where the Crown can point.
Where do you draw your bright line? You're saying it needs to be earlier than when they're labeled a suspect, but when exactly is this onus triggered?
This onus is placed on the Crown at any time the police approach an individual to conduct an interview in connection with a crime. And the reason for this, Justice, to turn to the second issue we have with the majority, is that accused persons are in legal jeopardy from the moment they begin their interaction with the police.
So your submission extends beyond accused persons to anybody who's an interviewee. So that means law enforcement who's investigating a shoplifting, jaywalking, speeding, any type of police interaction, in fact, with the public would be subject to this bright line rule. Would that not be incredibly onerous on law enforcement?
And counsel, just to build on that, you already gave your submission that this is an undercurrent that already underpins this part of the law. So in necessitating a solidified hard and fast rule, does that not remove the flexibility of, say, the police officers who conduct these investigations?
I'd like to address each concern one at a time, if I may. Firstly, it's our position that it does not undermine the latitude of police officers, because what this caution requirement does is it actually clarifies the law in order to shift the burden on police officers from the current status, which requires them to navigate the complexity of when someone becomes a suspect, and instead allows them to provide a clear, bright line caution right from the outset. And this would prevent a key issue that has arisen as a result of the lack of clarity of the confessions rule, which is, as the court held at paragraph 170 in the case at bar, that there is a great degree of variability in how lower courts rule with respect to voluntariness. And this,
Are you equating voluntariness with a caution or a warning? Is a cautioned statement necessarily a voluntary statement?
no, Justice, we're not equating them exactly. It's our position that a caution, and more particularly what it stands for, which is an understanding of the informational component of the right to silence, is a necessary but not sufficient condition for voluntariness, in that a caution must provide the informational component, but beyond that, the police are still accountable for not acting in ways that limit the ability of accused persons to exercise their rights pursuant to the Oikle factors.
Counsel, I'm glad you bring this up because, as my co-justices have mentioned, this is a very onerous thing. And the reason our law is the way it is currently is because there's a lot more to knowledge than simply telling someone. And so if we take your position and let every person who's interrogated in conversation with the police be informed, shouldn't we also have a translator every single time? Should the police not have to make sure that the person understands the right as it's given to them? And if we give that to every single person, are we not going to bring the entire police system to a grinding halt?
Justice, it is our position that that information must be provided to every person, but this would not bring the system to a grinding halt. And I'll explain for there's a two-part response to this. Firstly, that with respect to your concern about ensuring that everyone has access to the information, it is exactly access that we're advocating for. It's not, I'd like to clarify, the responsibility of the police to ensure that accused persons necessarily understand their rights, or rather that they have the responsibility to ensure that the accused persons or the interviewees make a good or wise choice. Rather, the obligation on the police is to make the information available in a means that is accessible to the interviewee, which in certain cases would necessitate a translator.
But what good is it to say that they've said it to them if they don't make sure they understand it? Like if you're not making sure, the police aren't making sure they actually understand their rights, it feels like we're just checking off a box and calling it a day.
We do want police to ensure that they understand their rights, and that is why we would advocate for the presence of a translator if necessary, as is an essential part of understanding their rights. But we would not go so far as to say that police have an obligation to ensure that they make a good or wise choice, and we would not want to place a burden on the police of proving subjective knowledge, which goes back to Justice Cooney's question about bringing the justice system to a grinding halt. Our position is grounded on the objective indicators of informational components that are provided by a caution. And these objective indicators can be supplemented or substituted by other objective indicators that fulfill the same function.
So counsel, would an objective indicator include, for example, asking to go outside to have a cigarette and being granted that request?
No, it would not, Justice.
Not be an objective indicator of a person being able to express their will?
It would not be an objective indicator of the person understanding their right to remain silent, because what is implicit in requesting to go outside for a cigarette break is that it is up to the police whether or not I'm actually able to exit the situation.
You see that the case law draws some connection between the ability to seek counsel and speaking to counsel with that right to remain silent.
Yes, Justice, but this falls under the Section 10 rights that arise at the point of detention. Our concern today is with the rights of the accused prior to the detention phase.
But it still informs, if I may, it still informs the analysis here. And so Mr. Tessier, after having a cigarette, went outside and he made a choice to make a phone call. He didn't call a lawyer, called a friend, but based on that conversation, he made different choices as it related to his DNA analysis. That, to me, suggests that there's some form of an operating mind at play here.
We concede that there might be an operating mind with respect to the DNA analysis, Justice, but it's our position that this does not necessarily transfer to the rest of the interview, and certainly not to the statements that occurred before he contacted his friend, because in terms of asking someone, again, it comes back to this idea that there is an implicit permissiveness that Mr. Tessier must seek out in order to exercise his right to silence. And respectfully, Justice, it's our position that police should not rely on accused persons' lack of understanding of the right to silence, or feel that they should ask for a right to silence in order for that right of silence to be available to accused persons. As the Supreme Court...
A hard time understanding with your position that every police interaction requires caution, if I understand your position correctly, is that when you look at Section 7, we're talking about the right to life, liberty, and security of the person. How is Section 7 engaged with someone who isn't a suspect, who is just a mere witness or a complainant in a matter that the police are approaching and interviewing?
Justice, Section 7 is engaged indirectly because the right to silence is intended to protect witnesses and interviewees against legal jeopardy that occurs when the state takes an accusatory stance against them and exercises coercive power. In the case of Oikel at paragraph 31, the court held that it may be appropriate to interpret the charter in light of the confessions rule and vice versa, because the similar concerns animate both of them. This legal jeopardy is not limited to the point of Section 7 or Section 10 rights being engaged at the point of arrest or detention, but rather it permeates the entirety of the interaction between accused persons and the police.
So do you understand, counsel, then why there might be some resistance to your position, to the extent that it appears to reinforce the notion that every time the police interact with the members of society that they are there to serve, that this is somehow an accusatory interaction, to use your word. Doesn't that undermine public trust in the police and make the relationship between the police and the people they serve more difficult?
I see my time has lapsed. May I briefly answer your question? Thank you. Justice, it's not our position that this is necessarily the case anytime police interact with individuals, but it is true that when police approach individuals in order to conduct an interview in connection with a crime, the accused person's, the interviewee's legal jeopardy does increase. And it's not our position that accused persons or interviewees or Canadians at large should be afraid of police, but simply that they should be aware of their rights in these interactions, which broadly, as the court held in 2019 in the case of the Queen and Lee, they are not, and they cannot be expected to be. This is a high burden to place. Ultimately, the decision of this court will decide the extent of rights protection for every future Canadian placed in the vulnerable position of a police interrogation. And with respect, Justices, a choice without knowledge of the alternatives is no real choice at all. Barring any further questions, this concludes the first submission on behalf of the appellant.
I do have one further question, counsel. What is your proposed wording for this new caution?
Our proposed wording, Justice, is simply that the police would inform the interviewee that you have the right to remain silent. Anything that you can say has the possibility to be used against you in a later proceeding. If barring any further questions, this concludes submissions. Thank you.
May I proceed? Good afternoon, Honorable Justices of the Supreme Court of Osgoode Hall. My name is Lesha Shah, and I will be concluding the final submission on behalf of the appellant, Mr. Russell Stephen Tessier, in the case at bar. It is the appellant's position that the Supreme Court of Canada erred in finding the Crown met the high evidentiary burden required to rebut inadmissibility in the absence of a caution. Justices, Mr. Tessier had a right to a free and meaningful choice to speak with police, and he was deprived of this right. As my co-counsel has submitted, the test should not require the suspect-non-suspect distinction. This is a distinction between our proposed framework and the current framework as reflected in the first stage of the analysis. However, even should this court find that this distinction should be made, it is nonetheless our position that Mr. Tessier was a suspect. In light of the pointed questions he faced, which were adversarial in nature, and the fact that the police were aware that Mr. Tessier was thought to have been the last person to have seen the victim alive. They further knew that the tire truck that could have been at the scene was owned by Mr. Tessier, and they further measured the tire tracks to ensure that this was the case during the first interview. They even went as far as to request a DNA sample for the purposes of ruling him out of the investigation.
Right, counsel, but if we say they should have assumed that he was a suspect, okay, I assume your friends are probably going to concede that, but that doesn't necessarily change the fact that this should be automatically excluded, does it? You'll agree that there's still a test to be followed, right? So what facts do you have relating to whether or not this is voluntary?
Yes, Justice, it is our position that there's still a contextual analysis under the second stage that reviews the constellation of circumstances. And in this case, we'd like to first point to the 2000 Supreme Court of Canada decision of the Crown and Oikel, which sets out 4 factors that, if any present, without anything to offset the unfairness created, amounts to a finding of involuntariness. Now, in this case, the point of contention is on the operating mind doctrine, and Oikel specifically notes that an individual will have an operating mind when they are aware of what they are saying, that it is to police that they are speaking to, and the statements can be used to their detriment in the investigation.
Counsel, sorry.
No, please go ahead.
Thank you. Counsel, it seems to me Mr. Tessier knew that his statements could be used against him. He made some positive assertions to the police, such as, I don't want to go down for murder or something to that effect. I don't want to get charged for murder. So he seemed to know that his statements could be used against him.
Respectfully, Justice, these statements were not made in connection with the actual statements that he was making to police, but rather the connection that the DNA sample would later lead to. He specifically noted this at paragraph 93, which refers to the purpose of the DNA sample. While he was aware that the DNA sample could later link him to the crime in question, he was not aware that this would further also connect to these statements as well, as he was only provided a caution for the purposes of the DNA sample.
But counsel, didn't he engage with the police himself? Like, he called the police, he sought them out to talk to them. So how does that not reflect that this was a voluntary act on his part?
Justice, there is no evidence on the record that indicates any intention on the part of Mr. Tessier. And rather, the evidence that we have indicates...
But what about the phone call? That seems to me to indicate an intention to speak to the police.
Justice, to that, I'd say that there is coercion at play, and the evidence to support this...
Sorry, there's a coercion at play when he's making phone calls and leaving voicemails, plural?
If I could refer your Honor's attention to paragraph 113 in the case at bar, Sergeant White asked Mr. Tessier if he could prove that he had not committed the crime, and even further insinuated that he was lying about his statements. This shifted the burden of proving innocence from Sergeant White onto Mr. Tessier, and so rather we can see the coercive element at play. And further, at paragraph 65, the Crown acknowledges that the coercive powers of the state can lead an individual to make involuntary statements, which is what occurred in this case.
What do you make of the fact that Mr. Tessier wanted to make sure that his interactions with the police were recorded? He knows this is a murder investigation. Does that not show that his wanting there to be a record of their interactions, that this is in play with the investigation at large?
Our position is that Mr. Tessier's awareness of being recorded is not a factor, and it's not an objective factor that we can rely on. Firstly, I'd like to also refer your attention to Hebert, which finds that proving subjective knowledge is an impossible task. And so in this case, Mr. Tessier was not explicitly told that the statements and the recording of the statements would be shared and used in the investigation. Rather, he was told on the outset of the interview that the purpose of the interview was to obtain a biography of his late friend. The police in this case significantly downplayed the significance, and so there is no way that we can expect Mr. Tessier to have been able to make this connection in his head absent.
Given the statements that he made, isn't it obvious that he intended the police to use these statements, maybe not against him, but he intended them to pursue them, to maybe go on some false leads or to have some other mistakes? But isn't it obvious from the statements that they were intended that the police receive those statements and use those statements for something?
And just to build on that, like, he knew enough to object to the DNA sample, but you were saying that he didn't know enough to also object to the statements that were being taken at the same time?
Justice, Mr. Tessier was told that the interview would be used for a biography, not that this would be used in the investigation. And so, absent a caution to fill the informational deficit, we cannot expect Mr. Tessier to have known this when he was told otherwise. And further...
In the interview, though, that was correct. He was not a suspect at the time when that statement was made, was it?
No, Justice, he was not.
So why is that statement a problem when he wasn't even a suspect at that time?
The issue is that even when he became a suspect during the course of the first interview, he was not cautioned. And so, because of this informational deficit not being filled...
Sorry, counsel, so is your position that he only has to be cautioned once he becomes a suspect?
That is not our position. Our position is that he should have been cautioned at the outset, as he was being contacted in connection with a crime, and he was aware of this. However, even under our friend's proposal, or the current framework, he should have been cautioned during the first interview, but he was not. And so because this informational deficit was not filled, Mr. Tessier was not of an operating mind.
When you say he should have been cautioned at the outset, are you suggesting that it's a requirement under the common law, under the current rule?
Our position is that the case law around this topic has evolved to a point that has recognized the increased importance of individuals knowing their rights. We went from...
So the counsel is not a requirement under the current rule, is it?
is not an explicit requirement, but we'd like for this court to take this opportunity to clarify the increased importance that has already been placed in the court's jurisprudence on the importance of the informational component of a caution.
Why should we do that under voluntariness? I mean, if we accept everything that you say was wrong with what the police did, why does that go to voluntariness? And why if you're asking us to rewrite the test on voluntariness, why couldn't we write something else? Or why wouldn't we use some other way to deal with what you say is essentially unfair treatment?
Justice, the court's jurisprudence has long understood that a meaningful choice in connection to voluntariness is an informed choice. This has been recognized since the court's ruling in Hebert, and more recently, in the case of Oikel, found the informational component to be integral to the finding of an operating mind. So it's not so much as we are requesting this court to rewrite the test, but clarify the importance that's already been highlighted in the court's jurisprudence.
Counsel, you brought up the idea of a meaningful choice. Okay. As I've listened to this, I haven't found a reason to believe that your bright line test equals a meaningful choice. I understand that the information might be there, but I don't think we've gotten to the point where this test is actually saying that the person understands it, knows it, and then meaningfully makes that choice. I'm not sure how this corrects the problem that we have here today.
It wouldn't entirely correct the problem on its own. Rather, it would ensure that the informational component that is necessary to make this choice is there. And so even when in cases that require a caution, such as Singh and Whittle, in those cases there is still a contextual analysis in weighing of factors under the second prong of the analysis. And so in this case, we're looking to these objective indicators that Mr. Tessier was not informed of his rights to silence. And so absent the information or any indications at all to prove that he was aware of this informational component, there cannot be a finding of voluntariness.
Counsel, as the law stands now, it's the Crown's onus to rebut the presumption of inadmissibility. You're suggesting, I presume, that now with your new test, the presumption would be if they were cautioned, it's presumptively admissible, and that's rebuttable by the defense?
Yes, Justice.
And what factors would a defense counsel use in terms of rebutting that presumption?
The court would still go under the, I see my time has nearly elapsed. May I answer your question and conclude?
Please do.
Thank you. The court would still have to do a weighing of the contextual factors, Justice, and so while, as it presently is stated, that there's a presumption of inadmissibility, there would be a weighing of factors that would indicate that that the statements were not voluntary. So the prevalence of any of the four Oikel factors, even in the light of a caution provided, would amount to involuntariness. To conclude, Justices, we implore this court to allow these bright lines to illuminate a path to a brighter future. For these reasons, we ask this court to allow this appeal and overturn the decision of the lower courts.
Thank you.
Thank you.
Respondents, thank you.
May I proceed?
Are you ready?
Good afternoon, honorable justices of the court. My name is Monique Ingram. With me here today is my colleague Elizabeth Hamilton, and we are counsel on behalf of the respondent, His Majesty the King, in the case at bar. Justices, this case is about allowing the authorities the leeway they require in order to conduct effective investigations. I will be addressing the respondent's first submission as to what constitutes the appropriate framework for voluntariness, and my colleague will be addressing the second submission, that in this case and under this framework, Mr. Tessier's statements were voluntary and are therefore admissible.
So I'm going to interrupt you right there and ask, you said that your main issue is that the police have the leeway, or that this is about the leeway that investigators need to conduct effective investigations. My question to you is, how would it stymie police investigations to advise the people they're speaking to that they have the right not to speak to the police?
Your Honor, it would essentially prevent important information from being told to the police when there are no concerns about fairness, therefore no concerns of vulnerability or risk of low risk of self-incrimination in a witness. Know
that there's no risk to the witness. What if this is a witness who's telling police something about, as one of my colleagues said earlier today, a crime boss, and they're called to court to testify? Wouldn't that put them into some kind of jeopardy?
Your Honor, we agree that some witnesses do face a risk of self-incrimination, and the respondent submits that cautions can be used for some witnesses. But in the court's analysis of voluntariness, the absence of a caution should not be determinative. Therefore, the police can conduct cautions as they please, pursuant to their discretion, but if they do not, in a situation where a witness does not face fairness concerns, the court should not find that their statements are inadmissible. This is because if a witness needs to be cautioned in every instance, statements will be withheld from the police.
Counsel, isn't part of the issue here that even the police got it wrong this time on when they were supposed to caution Mr. Tessier? So you're giving the police a lot of power when we know they don't always get it right. So why not be a little bit more proactive in this and make sure that they have to say it to everyone? Because to your point, there are some witnesses that do later become suspects.
And to build on that, there is a difference between giving the police leeway and giving the police unchecked power. And as far as I'm concerned, it seems like there'd only be a benefit to making sure that all Canadians are armed with the full knowledge of their rights. I don't know if I can necessarily see the argument that in some cases it's okay for people who are interviewed by police to not necessarily be aware of those circumstances. So can you speak to that?
Justices, I will answer your questions in three parts. Firstly, Justice Brennan, under our framework, voluntariness will still be analyzed. The contextual approach allows for circumstances to be analyzed by a trial judge who is in the best position to see if, based on the factors listed in OICL, but not limited to those ones, whether the individual was able to make a free choice to speak. It does not need to be proactive because this will actually harm police investigations, resulting in negative policy implications. A witness who is told they can be silent and that anything said can be used against them may feel alarmed. They may feel as though the police are taking an adversarial position against them, and they may even feel that if they do share their statements that are so crucial to the police investigation, they'll be...
Though, counsel, we have comparable common law jurisdictions where a uniform warning is in fact provided, and they seem to have law enforcement mechanisms and investigations that seem to be working quite fine. So where's the evidence? How can you conclusively demonstrate or point to an outcome that law enforcement efforts will be thwarted?
Justice, we recognize that some individuals will continue to speak when they are cautioned. However, others are vulnerable, especially to police questioning, and as such, they will be silenced when they feel they are not in the right.
The whole point, if they're vulnerable in those situations, they should know that they can say no.
Yes, Your Honor, and so if a witness is so vulnerable, the police do have the discretion to caution them. However, witnesses who are always cautioned when they are not vulnerable may fear that they will falsely confess where they will be forced into false confessions.
So-
Discretion, or is it a requirement where the individual seems to believe it?
Pursuant to the respondent's test, suspects require cautions. Witnesses can be given cautions up to the discretion of the police. However, when they do not exist in those cases, the absence will not be determinative of involuntariness pursuant to a contextual analysis of whether the police conduct in any way infringed an individual's ability to make a free choice to speak to them.
To be saying that we shouldn't provide people with the information about their rights lest they choose to exercise them. How is that tenable? How can you defend that?
Your Honor, the balance that has been so carefully struck by the confessions rule needs to be protected. And if the police ability to conduct investigations with the leeway they require to collect crucial information from witnesses is eliminated, it will essentially turn into an upset balance that favors the accused at an unfair amount.
It doesn't sound like you're saying, I don't think it would be accurate to say that the risk is that they're not going to be able to do their job. I think what you're saying is that they're not going to be able to do their job as easily. So why should we prefer convenience for the police over charter rights of citizens?
Your Honor, the police require this important information from witnesses that they can take when there are no vulnerability concerns without a caution, because it protects the rights of the individuals who are the victims in the crimes that they are investigating. And if they don't have the information they need to charge an individual, then society's interest will be unduly limited. The confessions rule, as it stands today, already protects the accused at all stages of the criminal investigation, and they are given additional protections that they do not see under the Charter, which allows the leeway for the police to be justified.
But is that not grounded in things like the presumption of innocence? And if we apply what you're saying, would that not be jeopardized?
No, Your Honor. The protections that an accused still sees under the confessions rule would be unchanged and can remain balanced when the police are allowed to conduct investigations with witnesses, and if they decide not to caution, to have those statements not determinative of involuntariness pursuant to a further contextual approach. An accused already, under the confessions rule, is protected further than they are under the Charter, since it applies in all contexts, not merely to detentions. It is the Crown's burden to prove beyond a reasonable doubt at a very high bar that statements are still voluntary in the absence of a caution.
Counsel, you said earlier that there doesn't always have to be an element of proactiveness when giving a caution in this case, for example. But you had also said that if the police, you can correct me if I'm wrong, but this is what I heard in your submissions, that if the police recognize that someone is of a vulnerable population, they can choose to give that caution to sort of help stymie that. But does that not in and of itself import sort of like a proactive or preemptive knowledge on the part of the police, which in turn seems like more work on their part than to just, as a blanket rule, give the caution to everyone to make sure everyone's uniformly advised of their rights?
Your Honor, we would not want to provide a blanket rule about cautions in the same sense that my friends do, because it does not result in proper assessments of voluntariness and will result in very fairly made and reliably made statements to be thrown out at trial. And we do think, we submit that the police should be given this discretion, and it wouldn't be difficult for them to gauge how they should treat individuals they're speaking to. The police are well trained, and
So going back to a comment I made earlier, in this case, they couldn't even assess when he was properly a suspect. Like, the investigator couldn't make that determination. So you're saying even earlier on, with less information, they can make that one?
Your Honor, if the discretionary choice of the police to not caution a suspect is found to be incorrect, as it would be under our approach, because that would result in a prima facie finding of involuntariness, the contextual analysis effectuated by the courts will be able to assess any of these issues of a potentially incompetent investigator. However, we cannot make a bright line rule for cautions, since, as highlighted in Boudreau, this would neglect an important part of the confessions rule and of voluntariness itself, and that is reliability.
Counsel, you concede that your approach at least promotes some measure of inconsistency among lower courts in applying this contextual analysis?
No, Your Honor. though my friends may have submitted that the lower courts have been using this in a variable sense, it is incorrect to state that the 4 OICL factors are treated as a sufficient checklist for involuntariness when the court and OICL themselves stated that it should not be treated as such, and other factors in our court's jurisprudence, like the ones my colleague will submit today, drawing on Pepping, Booth, and Blackmore, etc., can be included under a contextual analysis to see, based on the totality of the circumstances, did the individual make a voluntary choice to speak to the police.
Counsel, the voluntariness analysis, the contextual analysis, takes place in a voluntariness voir dire, correct? You just used the phrase incompetent investigator. That incompetent investigator will be called as a witness on the voir dire. How are we to have any faith, or how do we trust the police officers who you just said yourself may be incompetent? How can we rely on their subjective determination as to when a witness crystallized into a suspect?
Your Honor, under the respondent's test, the determination of a suspect is an objective test, and it will look at the objectively discernible information available to an officer and how a reasonable officer would interpret the accused's involvement in the crime. As such, even if an officer at the time did not give the caution they required and the context needs to be analyzed, it will be taken from the objective point of view that the court can determine in a more accurate sense were these statements voluntary. And under this contextual approach, it allows for the proper assessment of statements instead of the exclusion of voluntarily, fairly, and reliably made statements to the court. To conclude, the framework for voluntariness should not require that cautions be mandated for witnesses, and nor should it find the absence of a caution determinative of involuntariness. Barring any further questions, this concludes the first submission on behalf of the respondent. Thank you.
May I proceed? Good afternoon, Honorable Justices and Chief Justice. My name is Elizabeth Hamilton, and I will be completing the final submission on behalf of the respondent, His Majesty the King, in the case at bar. Our final submission is that in this case, Mr. Tessier's statements were voluntary and thus admissible. To begin, sufficient weight should be given to the absence of a caution. However, not to the point where it outweighs the entire context of the circumstances. Under the appropriate contextual examination required under a voluntariness inquiry, the absence of a caution did not undermine Mr. Tessier's free choice to speak to police.
Counsel, what evidence is there to support that Mr. Tessier's decision to speak to the police was voluntary?
Justice, we would take the cases of Pepping and Booth to show that courts have been satisfied in the contextual examination that statements were voluntary, since the suspect was aware of the consequences of making those statements despite absence of a caution.
I think my colleague was asking about Mr. Tessier in particular.
In Mr. Tessier's particular circumstance, as in Pepping, he was aware that his statements were being recorded for the investigative purposes of Mr. Burdell's homicide.
But he wasn't aware that he was being investigated. Is that not an important distinction?
Justice, at moments during that recording, not only did Mr. Tessier ensure that the recording was still live, because he wanted a narrative caught on tape, his own. Mr. Tessier was attempting at various moments to craft an image of concern and...
So does the fact that he was crafting this narrative that you're claiming actually speak to the fact that it was voluntary? He could be doing that because he felt like he had no other choice but to speak to the police.
Also, what proof is there of that? Is that not just an inference based on perhaps the police's perception of what the statements that he was giving?
Justices, the entirety of the exchanges show an eagerness to talk on Mr. Tessier's
I'm
behalf.
glad you brought up eagerness, counsel, because that's the first part of the Pepping test. The second part requires knowledge of the fact that this information will be used against him. Where do we find that in the facts?
Your Honor, importantly, the operating mind doctrine that my friends would overextend through their analysis does not require the proof that the accused was subjectively aware of their right to silence or aware of the personalized consequences of speaking to police in their own circumstances. Though when demonstrated, this of course can be powerful evidence that the statement is in fact voluntary. However, at no point in a contextual examination is it mandated to show Mr. Tessier subjectively knew his right to silence, rather that his overall behaviors and statements were voluntary. To decide otherwise would not only again amount to an overextension of what the law dictates, but it would add an additional mental element that would impose an untenable standard onto trial judges in having to assess whether suspects subjectively knew and were aware that they were not required to answer police questions on their own specific risk, impeding a trial judge's ability as the best person to exercise discretion in light of all the facts, weighing all contextual.
Is it untenable if we require a caution and we have the answer, and isn't the trial judge in a perfect position to assess that?
Yes, Your Honor, we agree a trial judge is in the best position to assess that. However, a voluntariness inquiry must not be limited to equating voluntariness with a caution. Instead, a broader approach, one that analyzes the context of other factors such as those mentioned in Pepping, the absence of police trickery, threats, inducements, and oppression, none of which are at play in the case here.
What about the fact that Mr. Tessier said, I think it was when, in context of the DNA sample, that he said he was afraid, that he didn't know, he was afraid of, I think, answering the questions, and he didn't know what to do. Doesn't that kind of speak to subjective mind? And even though it's not required to look at, can we really ignore that evidence?
Your Honor, I will answer your question in two parts. Firstly, the statements Mr. Tessier made that he was nervous, again, have not been subjectively proven, as is not required by law, to show what his subjective thoughts were at the moment of that instance. For example, an interviewee may feign subjective nervousness to further deflect suspicion away from them. Secondly, at no point was Mr. Tessier's legal jeopardy obscured or eluded from him. It was clear from the beginning that he had not been eliminated from the investigation, a point made directly when Sergeant White explained the purpose of obtaining DNA and asked him whether or not he had killed Mr. Burdall.
Counsel, you brought up a great point here. But we've talked a lot about the objective factors of Mr. Tessier. And what we haven't talked about is the objective factors of when the police should have given this statement or warning. And as your co-counsels brought up, that we should trust the police. We should trust them to do their jobs. But in this case here today, we couldn't trust that officer because they never gave that statement when all the objective factors are pointing to that they knew he was a suspect much before that. And so if we're going to trust that, we can trust the objective points of Mr. Tessier, why are we also then trusting or not trusting the objective facts of the police?
Your Honor, it is true no police officer is perfect. However, even in the absence of a caution at the outset of the interviews, prima facie raises involuntariness concerns. The record substantiates that the appellant had an operating mind, and there was no evidence of police misconduct that vitiated that voluntariness, thus discharging the Crown's burden beyond a reasonable doubt. Moreover, if a witness becomes a suspect at some point in time during an interview, It is possible for a caution to be provided in an informal and a non-threatening way, not chilling investigative tactics of police officers, as my friends would be asserting.
How is that going to play out in real life, where an officer is having a conversation with a witness, and then subjectively the officer determines that this witness might be a suspect? Midstream, the officer now is to be trusted to stop the investigation just as it's getting juicy, and advise the person that they have a right to remain silent. How is that conducive to more open information gathering for police? How does that even help the police advance their investigation? It seems to me like in the moment when the officer may be making progress, the officer is going to then be saddled with this constitutional duty.
Your Honor, police officers and law enforcement are in the best position to answer the exact details of how that would occur. What is at question in this court is the fairness at stake, and it would be fair at that moment for perhaps the police officers to pause that interview, resume it at a later time after a caution is provided, or alternately continue by giving a caution in an informal way that relies on the substance, that relies on the substance and the content rather than the form itself.
Would it be unfair for the officer to give the caution in, to use your language, a non-threatening way at the outset? Where's the unfairness to it at the outset in a non-confrontational, fair way?
Yes, Your Honor. As Sergeant White testified at paragraph 138 in the case at bar, this could cause an undue uncomfortability with suspects, with witnesses who are at a very low rate of self-incrimination risk at the outset of interviews, possibly stymieing their desire or their ability to talk to officers. However, yes, sir.
But what is more important, the investigation into the homicide in this circumstance, or Mr. Tessier's fundamental rights and freedoms that attach to every single Canadian?
I see my time is elapsing. If I could request an additional minute to answer your question and briefly conclude. Neither is more important. It is a balance that must be struck, and the appropriate right point of equilibrium between protective principles underlying the confessions rule and police investigative abilities would be to only allow a prima facie involuntariness rule for suspects and allow a contextual approach to be given to all statements, whether from witnesses or suspects at every moment a live issue of involuntariness is raised.
Counsel, you have 2 minutes remaining, so I want to ask you a question. You made a statement earlier. You said something about what the appellants are suggesting would be an overextension of what the law dictates. Agreed, that would be an overextension of how the law stands now, but that's what they're asking this panel to decide, to extend the law. So my question to you is, let's talk about Mr. Tessier. He comes into the police station. He's cautioned immediately. He decides, I don't wish to speak to the police. No, thank you, officer, and he leaves. Aren't there still investigative avenues open to the police? Does their investigation end because he doesn't wish to speak to them?
No, Justice. The police, of course, can pursue other methods of investigation, perhaps, again, at another point in time, initiating contact with Mr. Tessier. However, it is not a determinative factor that at the beginning, at the outset of every interview with a witness, they must provide this in order for it to be prima facie involuntary. For the case of Mr. Tessier, there was at moments, at multiple times during the investigation, during that interview, he showed his willingness to participate, his eagerness to participate by inviting police questioning on the victim and his relationship to the victim, and also inviting them back to his home to sort through victim possessions. That he was trying to deflect suspicion means that he knew that he not only held options of how to cooperate with police, but he specifically chose the one that he believed to benefit him the most.
Counsel, I'm glad you brought that up, because I've been thinking about this idea that we are not considering, or you're asking us not to necessarily consider the subjective knowledge of the accused person, Mr. Tessier in this case, versus believing the subjective opinion of, say, police officers who are conducting these interviews, like as the statement you just gave, the crafting of the narrative, the demeanor, the fact that he was sussing the police officers out, for lack of a better way to say it. So why is it we're dismissing the subjective knowledge of Mr. Tessier, but it's okay to consider the subjective knowledge of the police officers, especially when you spend all this time advocating objective standards to us?
Your Honor, I see my time has now elapsed. If I could request an additional minute just to answer your question and briefly conclude.
Go ahead.
Regarding the objective factors, police are in a position to not only provide justice to the victims of crimes, however, they are also acting within the interest of society's public safety. In order for them to properly administer the law, there should be analysis of when someone does or does not become a suspect, mandating different behaviors and police tactics in order to get to the bottom of criminal offense. These objective indicators can later be looked at by a trial judge to ensure that not only was there absence of misconduct on behalf of police, but that any statements made involuntarily could be still excluded. To briefly conclude, to preserve the balance between individual rights and societal interests, my friend's framework should be rejected by this court. The respondent respectfully requests that this honorable court dismiss the appeal and uphold the trial judge decision. Barring any further questions, this concludes the respondent's submissions. Thank you.
Is there any reply from the appellant? Okay, thank you. I'd like to express on behalf of the entire bench our appreciation for very able and helpful submissions from counsel. We're going to need some time to think about what we've just heard. So this hearing is adjourned.
All rise.
Okay, please have a seat, everybody. Let's step out of role here. I'm not in my role as Chief Justice anymore. We have deliberated and we've taken off our judicial caps and robes, and we're here now to celebrate a wonderful display of oral advocacy from our four very competent and able finalists. I want to thank the competitors for bringing their A game. We witnessed today really the best of the Osgoode Cup, top shelf advocacy, which resulted in a very difficult and close decision for the bench. And I'm sharing that with you confidently. And I think it's not a surprise to anybody that was here who witnessed this final round that we saw four very competent and persuasive advocates that leave us, who are trying to make a decision about which side was more persuasive and convincing, that leaves us in a difficult position to determine which way to go. So after much deliberation, we were able to reach a split decision, a 5-4 decision, which is about as close as it gets, but it was a decisive decision. That is, the decision stands as it is, as you all understand, that regardless of the split, regardless of whether a decision is unanimous or deeply divided, once the decision is made, it is the decision that is the law, and it is what we will all stand upon in moving forward. And to that end, I'd like to announce that our successful team is the appellant's team, the team of Navya. In congratulating Navya and Lesha, I'd like to also acknowledge an excellent performance by our respondent team, Elizabeth and Monique. Thank you to all the judges and all the participants. And please enjoy the presentation of the trophies to all 4 competitors.
I feel like we're coordinating pictures. I've been asked to just say some quick closing remarks. I don't have much in terms of formality, but I'd like to formally call to close the 2023 Osgoode Cup. It's been a great 19th Osgoode Cup. I hope everybody considers coming back for the 20th, which is going to be next year. Wow, we're turning 20. Can you imagine? And, really, I think that's going to be exciting, and I hope to see all the schools back, the competitors who are eligible, and those of who do choose to move on to, say, law school, come and find us. And we always like to have judges and people participating in the committee afterwards. So we're going to stick around for some pictures. There's going to be the banner here, but this calls to close the formal part. Thanks, everyone, for all the help, and congratulations to everyone.